Hear ye. Court of Appeals for 14th District, Texas, now in session. Soon to adjourn. God save the Constitution and the Honorable Court.
Good afternoon, everybody, and welcome to the 14th Court of Appeals this afternoon. I'm Justice Kevin Jewell, and with me on the panel today is Justice Cherry Zimmer and Justice Megan Hassan. We have one case on the docket this afternoon, and that is number 14-19-959 CV, Bruce Hotze versus Sylvester Turner and the City of Houston. The court is allotted 15 minutes per side for argument today, and I understand that the appellant wishes to reserve 5 minutes for rebuttal. Is that correct?
Yes, that's correct, Your Honor.
Okay. Can all counsel see the timer on their screens?
Yes, Your Honor.
Okay. All right, then we will begin, and we're ready to hear from counsel for the appellant.
May it please the court, this case started way back in 2004. There was an election in Houston. The voters had a chance to vote in favor or against two charter amendments. Those amendments are called Prop 1 and Prop 2. Prop 1 was sponsored by the city. Prop 2 was sponsored by the citizens through a petition. Both passed by a majority of the vote, but Prop 1 passed by a higher majority than Prop 2. On this case, this is now the third time we've been through the appellate courts. And where we are today procedurally is we were on competing motions for summary judgment. Previously, we were able to get through all of the challenges on standing and immunity. So now we're on the merits. And in these competing motions, our motion basically said Prop 2 is valid. The city's motion basically said Prop 2 is not valid. And the trial judge ruled for the city and granted their motion and denied our motion. So we've got competing motions, and this court is on a de novo review and can substitute its judgment for whatever it thinks is the correct judgment if you disagree with the judgment the trial court entered below, which was a take-nothing judgment. But we're not appealing anything about Prop 1 and whether the city complied with that proposition. That's out of the case. All we're focused on right now is Prop 2 and whether it's effective. The trial judge entered an order which he incorporated with the final judgment. That order is dated September 16th, 2019. And he made 5 legal conclusions and findings of fact. We agree essentially with all of them except one. So we're happy with the findings that he made, except for one. And his finding that we're challenging here was that Proposition 2 wasn't effective because he believed that Proposition 1 contained a clause that rendered Prop 2 ineffective. We have a disagreement on what we call the clause. It doesn't matter. I've been calling it a poison pill clause for 15 years. The other side in the last 5 or 6 years has been calling it a primary clause. It doesn't really matter. Here's our argument for why the trial judge got it wrong on that one finding. 3 things. The poison pill provision was never included in Prop 1 when the voters voted. Point 2, even if you think it was, which we don't agree, it wasn't effective for reasons I'll explain. And number 3, even if you think it was included and effective and triggered, the problem is that it would then be unconstitutional, which I'll go into in a second. So the not included, there's 6 pieces of critical evidence. I've cited all of this in the brief, but I want to raise it to your attention. First of all, wouldn't you think that what the city's version of the propositions 1 and 2 would look like would actually be in the charter? I checked it again just before we started this argument. If you look on the city's website and look at the city's charter, it lists Prop 1 in 2 different places. Basically, it's in Article 3, which is taxation, and Article 9, which is general provisions, Section 20. And then Prop 2 is listed in Article 6A, which is the budgets section of the city charter. The poison pill language isn't in there. So if you look at the charter right now, you'll see that the poison pill language isn't there. That's point one on evidence. Number two, there was a canvass. As you know, after you have an election in November of 2004, you have to have a canvassing order entered by the city. And they did that on November the 9th. That canvassing order, which is in this record, doesn't have the poison pill language in it. It quotes all of Prop 1 and all of Prop 2, just like is in the city charter this very minute, doesn't have that language. That's the second point. It's not in the canvassing ordinance. Also, that canvassing ordinance says on page 2 that we hereby order that this is what was passed by the electorate. And so they're saying that went before the voters was everything but the language of poison. Number three, it's not in the newspaper notices. There were two sets of notices that went out before the election. That language that says that Prop 2 is ineffective if it gets less votes than Prop 1 isn't in there. Number four, it's not in the ballot language. So when you went and voted and you looked at the ballot, the language doesn't have it in there. There's two more things, though, that I have to probe a little deeper. Number five, it's not quoted in the election ordinance. I'm not saying it's not in the election ordinance. It is, but it's not quoted. So what the city did, this is before the election, the city actually put in quotation marks all of Prop 1. And then at the end of the proposition, after you're finished with the quotation marks, all of a sudden, they put it in there. And it's this poison pill language that says, if there's two or more and one gets more votes than the other, then the top vote getter wins, the other one goes out the window. That's in there, but it's not quoted. Now, yesterday, the city filed a letter brief with you, trying to make the point through congressional and state legislative materials that the fact that the poison pill language isn't in the quotes doesn't matter. I'm surprised that they filed that, because if you read it carefully, and I have now 3 times, what they're saying in those periodicals is that you don't have to explain in quotes where you're placing the law that's being passed. And I agree with that. What happened here is when the voters passed Prop 2, it was placed in Article 6. A or 7A rather in the charter. That's a decision that the city can make. It can decide where to place a law if it passes. So they don't have to quote where they're going to put it. But that's not to say that if they want to have a poison pill that's going to eradicate one of these two things, that if it's passed by the electorate, it doesn't have to be in there. It does. And it absolutely would need to be quoted. The last point on this issue has to do with the adoption ordinance. Now, I had to mandamus the city to force them to adopt Prop 1 and 2 and put it on the charter. And when they did an ordinance, this is now way out in 2005, multiple months later, they just put in a gratuitous self-serving statement that, oh, by the way, Prop 1 includes the poison pill language. It's not true. And that was written by Scott Atlas, a lawyer for whom I have the highest respect, who was representing the city back then. Self-serving statement. It's not true. They can't just by city council ordinance fiat say that something was voted on by the voters when it wasn't. So it was never included.
They couldn't do the opposite either, could they? Can they by fiat remove language that the voters voted on?
No, they cannot. So the voters are the ones, they're the sine qua non of whether it's in or out. So they can't add and they can't subtract. The Constitution says that when you vote on a charter amendment, whatever gets passed by the majority is what has to be put in the charter. And so the Texas Constitution and 9005A of the Texas Local Government Code are the second reasons when I told you it was never included, but also never triggered and then never effective. Those are the reasons why it's never effective, because you can't just take two election outcomes and then just decide, we like one of them, but we don't like the other, so we're going to get rid of one of the two. You can't do that That's unconstitutional. They're either in or they're out, and you either vote them up and down or not. You don't have to vote for one and then think, oh, I have to also vote for the other in order for the one to work. No, it's all separate, one by one. And the
Mr.
last
Taylor,
point I wanted to
can I
make-
interrupt you just real quickly? Proposition 2, is that language in the city charter today?
It is. It's in section, I'm trying to find it here, Article 6A, budgets. And that's my last point before I run out of time. Prop 2 has to do with budgeting, has to do with whether a budget can be approved. If you are going to spend more than the caps allow, then you can't do it without voter approval. So it has to do with the back end of spending. And that's why it's in the budget part of the city charter. Prop 1, on the other hand, is rev cap. It has to do with levies. The actual language says you can't levy. And remember, you assess, you collect, and you spend in the process. And so when you can't levy, they're talking about the front end. You can't spend, they're talking about the back end. That's why those two propositions peacefully coexist and they're not inconsistent.
Mr. Taylor, let me ask you one more question. If you will assume with me that the what you call the poison pill provision was included in Proposition 1, if we were to agree with you that the provision is unenforceable, as you contend that it is, does that mean that all of Proposition 1 is unenforceable?
We're not challenging Proposition 1.
Okay.
So we have nothing to say about its enforceability. All we're saying is that as enforced, it doesn't include a poison pill that trumps Prop 2. Or if you think it's in there, then it cannot be rendered constitutional because of what I said about Texas Constitution, Section 11, Section 5. You just can't do it that way.
Okay. Any further questions?
Not at this time.
Okay. Thank you, Mr. Taylor. We'll hear from you on rebuttal.
May it please the court. What I'd like to do today is to address Mr. Hotze's appeal first, because the city does have a cross appeal. I think the most efficient way to do that in the limited time that we have is to try to approach these issues kind of on two tracks. The first is the one that Mr. Taylor has talked about, which is the primacy provision, which is what we call it, what it is, of Proposition 1. Is that valid and enforceable? But even if it's not, is it a statement of intention? Is it a statement of inherent incompatibility between that provision and Proposition 2 that would trigger the city charter provision, Article 9, Section 19, that would create a conflict and also render Proposition 2 unenforceable? Now, the problem I think that we have with Mr. Taylor's lovely exposition of all this is that there is absolutely, positively no law to back him up. He didn't cite any, hasn't put in any in his brief, and has produced not one shred of evidence that somehow this lovely theory that he has concocted has any legal grounding at all. Sounds really good, but there's nothing to hold it up. Instead, what you have is very well established election law that says two things. And frankly, this is the election law that he cites saying that we violated it, when in fact we didn't. We passed an election ordinance, which is our exhibit, Defendant's Exhibit 1, which includes this primacy language in it. Second, we passed Defendant's Exhibit 4, which is an adoption ordinance, which says this is what was adopted. It has the same language in it. And that is what is comprised under Section 9 of the Local Government Code. That's what it takes, the mechanics of what it takes to get something into the city charter. And under the common law in Texas, under the case law in Texas, that those activities lead to two presumptions: a presumption that the voters were aware of those provisions, and second, a presumption that they relied upon them. And the Black versus Strength case that we cited in our brief says they effectively create a contract with the voters And if you breach it, I think Justice Zimmerer had that point, is the city able to just ignore this language? No, it's not, because Black versus Strength says that it's effectively a contract with the voters. Now, again, Mr. Taylor has said that, all of these objections about what was in quotes and everything, what we have said in our brief and what he conveniently forgets is that all of these process objections to whether it was published or not should have been part and parcel of an election contest, which was never filed in this case. In fact, he has lost two cases, or excuse me, he's won one case, but he's lost a case under Rule 9.04 Hotze versus White, where they said that all of these kinds of things should be part of an election contest. And if you don't file an election contest within 30 days of the election, you waive all of those. So all of this lovely stuff that he talked about has been waived by his failure to do that. And that includes publication, that includes ballot language. We had no obligation to put this ballot language in there. In fact, the Supreme Court in the Dacus case, this court in the Bertrand case, and I think it was this court in the Bryant versus Parker case, all said that language of implementation, which is what the primacy clause is, language of implementation is not a chief feature and therefore need not be on the ballot. That doesn't mean, however, that voters didn't know about it. As we go into lengthy detail in the brief in both the election ordinance, these were presented as mutually exclusive. The language was in both of those ordinances, and the voters were well aware of it. I think we cite to 13 different articles where this was presented to voters in that way. His objections then, he sort of laps over from process objections to more substantive ones. One of these is this quotation marks thing. Again, how it was listed, how it was presented to voters is an election contest thing, which he's waived. But he makes the argument that somehow it just disappears. I would call the court's attention, though, to Defendant's Exhibit 1, which is the language of Proposition 2. And it has language outside the quotation marks that says, the city charter of the city of Houston shall be amended by adding new Section 7 to Article 6A to read as follows. If you go to Austin, there's every one of the bills over there is going to have that kind of language. Now, what he has conveniently done, what he argued in his brief, was that if it's not in the quotation marks, it's not in the law, period. Not in the law at all. And now he's corrected that and said, well, the placement stuff is okay, but any other stuff isn't. No. The drafting guides that we sent you yesterday, I think, are pretty illustrative, that there's a structure to laws. There's captions, there's certain language that has to be in there. And one of the things that you can have is amendatory instructions. And that's exactly what this is. It says that, if you've got language here, if you have this one, you can't have another one. And that's part and parcel of Proposition 1. And there's not one shred of law that says that it's not part of it. He then goes into some substantive objections. Again, Section 9.004, he says, is violated. Unfortunately, that was not ever something that he pleaded or argued below, so it's not preserved. But even if it were, the court in Hotze versus White said it was an election contest issue. As to 9.005A, which he also says is violated, that was decided in Ray Robinson, and they said the city had a ministerial duty to at least put it in the charter, but the court would not express any opinion about whether it was enforceable based on the primacy provision in Proposition 1. And I think that points to an important point, because all of his objections deal with the mechanical issues. They don't deal with enforceability. And the court in Ray Robinson didn't do that either. That's a matter of interpretation of the statutes and the validity. And there's nothing to indicate that the primacy provision is not valid. There's no other conflict with any other general statute. Now, he tries to say that there's a conflict under the home rule provision of the Texas Constitution, but that's something, again, that he abandoned in the trial court. And this case has been where they drop an argument, they don't respond to it, the court doesn't rule on it, and then they try to revive it later. He can't revive it now, so that one's been dropped. But even if he hadn't dropped the argument, you don't get a second bite of the apple if you fail to file an election contest by saying, well, even though I can't challenge those directly, I can say that there's a conflict with law. No, again, you're dealing with the mechanics of simply passing something, but not with their enforceability. So there's not a conflict here. Finally, they don't really deny that the court in Dacus and Bertrand reaffirmed that all of those kinds of objections were filed in the wrong court. They should have been in an election contest. They also don't dispute that Proposition 2 falls squarely within that primacy provision. Now, Mr. Taylor's going to get up there, because I've heard it before, and he's going to say, this is a spending cap. This isn't anything to do with revenue. I call the court's attention again to Defendant's Exhibit 1, which is a copy of what was on the ballot for Proposition 2. And it is a charter amendment relating to limits on combined city revenues. It talks about needing voter approval for increase in total revenues. And we've given you some other citations before. These were two competing revenue caps. Ask Mr. Taylor when he comes up here the next time, if it was just a spending cap, could the city collect whatever it wanted, establish a rainy day fund, run a surplus? No. The whole idea of both of these provisions, what's stated in the whereas clauses of the election ordinance, is we were looking for property tax relief. People didn't want to pay anymore, and they wanted to limit what the city could collect in revenue. And that's what both of them do. So when he keeps calling it a spending cap, read the ordinance, read what it says and what it does. The only reference it makes to the budget is how you check to make sure you've capped revenue. Because if you spend more than the cap, then that means that you've done something wrong. But it's not a cap on any kind of spending. So with that, I'd like to, if there aren't any other questions, I'd like to move.
I have a question.
Sure.
If Proposition 2, under the pre-vote ordinance, as it's worded, if Proposition 2 had received more votes than Proposition 1, is it the city's position that Proposition 1 would not have become effective at all, or that it would become effective nonetheless?
Absolutely. It would have gone by the wayside.
Okay.
And the idea was
And
that,
why is that?
well, the language applied to both. It said that if there's another revenue limiting charter amendment in this election, which there was, and it gets more votes, then this one shall not become effective. So the city was just as subject to having one rendered ineffective. And what would have happened is we would have enforced Proposition 2 and not Proposition 1. So it applied equally to both. So this was not, and I think this is an important point. This was not the city trying to come in and underhandedly slipping in stuff. Nothing was done underhandedly. Everything was done transparently and in plain view. It's hard really, I think, to argue, although Mr. Taylor manages to do it, that you're hiding something in an ordinance. So it would have been bilateral, if that answers your question.
Well, I have a question about that. So I see it in Proposition 1. I don't see it in Proposition 2. Are you suggesting that the language in Proposition 1 was mutually applicable?
Yes, it was.
What I'm reading is it says, if another proposition for a charter amendment relating to limits on increases is approved at the same election time as this proposition, the proposition, and if this proposition receives a higher number of favorable votes, then this proposition shall prevail and the other shall not become effective. I'm not seeing that as mutual. I'm just seeing that as if another proposition other than this one.
Well, I mean, the way we read it, I think their pronouns aren't very good, but if this proposition receives the higher number of votes, then this proposition, which refers to the proposition that received the higher number of votes, the other one, shall prevail, and the other, which it didn't matter. At least the way we have interpreted it is that it applies to both, because the idea is that these were presented as mutually exclusive, and there's not really any way to reconcile them, which I can would like to have a chance to talk about a little bit. And so even if ours got the fewer number of votes, we didn't want it to kick in. We wanted to go with the other one. And that's the way we interpreted it. It may not have been drafted particularly beautifully.
Why don't you go ahead and talk about your cross appeal?
Okay. As I suggested earlier, I think there are a couple of reasons why this should be why Proposition 2 should also be rendered ineffective. If for some reason the court doesn't like the primacy provision, it should also be rendered ineffective under Article 9, Section 19 of the city charter, which deals with conflicts. And the first thing is that whether it's effective in and of itself as freestanding law, which is what we think it is, outside the quotes as it is a statement of intention that one cannot stand in the presence of the other. Whichever one applies, one cannot stand in the presence of the other. That's a statement of intention. It's a statement of inherent incompatibility, and that alone ought to trigger the conflict provision. In fact, we cited to some case law out of California that has a lot of these kind of alternatives on there. And they've said that basically that kind of language should be treated as creating a conflict. Number two, there are several provisions in the difference in the provisions of Proposition 1 and Proposition 2 are insurmountable. The first is the authority of the city of Houston. Proposition 1 says that other than for ad valorem tax and water and sewer rates, the city council has complete taxing authority. Proposition 2 says it doesn't have any authority on those things. That's irreconcilable. There's no way to get around that. The second thing is compliance. One measures compliance by the annual tax levy. One does it by audits and provides for refunds, which are not provided in Proposition 1. And then finally, in dealing with property tax increases, there's also a requirement of voter override. The voters can override this. In Proposition 1, it's 50%. In Proposition 2, it's 60%. And if you fall in that 10% somewhere, there's no way to reconcile that difference. The final one is on property tax increases. Because Houston has the Proposition 1 has two different measures of revenue, and you have to take the lesser one. What you will end up with Proposition 2 is Proposition 2 may authorize an increase, where Proposition 1 will say, no, you have to use the lesser, and there has to be, you can't increase it that much, and there's no way to resolve that either. So we think that all of those things get you back to Section 9, Section 19, even if for some reason the court reverses the trial court on the primacy clause, which we don't think you should do. And if there are no further questions, my time has been exceeded.
All right, thank you, counsel.
Yeah, proceed.
Please do.
May it please the court. I want to start with the argument that this was an election contest. Think about it. We've survived 3 rounds of appeals. We've been to the Supreme Court twice. We've been to the Court of Appeals now 3 times. We've been through the trial court 3 times. Do you really think this is an election contest? Under election contest, which I do all the time, I'm an election lawyer, you have to file it within 30 days of the canvassing order. Otherwise, you're jurisdictionally barred forever. So this case wouldn't exist if it were an election contest. Think about why this isn't an election contest. The document I held up in my opening arguments, the canvassing order, that's what starts the clock for an election contest. That order was entered November the 9th, 2004. So early December, I would have needed to have filed an election contest. But guess what? There's nothing in the canvassing order that we're upset about. We're asking to enforce the canvassing order. The canvassing order doesn't have the poison pill language in it. It tells the truth about what's actually in the 2 propositions that were passed. So the argument is ludicrous that we would file an election contest on something that's perfect and that we're trying to enforce a decade later. Finally, on this argument about inconsistency, I want to make sure I make that really clear. So the first layer of my argument is that the poison pill's not in there for all the reasons I've said. The second argument is that the poison pill language, if you think it is in there, was never triggered. And that's because these two propositions don't relate to the same thing. The ballot language that she cited, that's authored by the city. That's not authored by us. What's authored by us is the actual text of Prop 2. And if you look at the prop, what it says in subsection 2 is that the budget must comply with Prop 2. And you can't spend money in excess of the Prop 2 cap. That's the backside. Prop 1's talking about levy. So let's think about property taxes. You get a bill in the mail. You have a time to protest. If you don't protest, then eventually it becomes due in October, late in February. You got to pay it. So I just described the levy, assessment, collection part of the process. Then once all that money comes in, the city council passes a budget. It's an ordinance that the mayor signs and presents. And we've challenged all those ordinances because what Prop 2 says is you can't spend more than the definition of the mathematical formula in here. You can raise it all you want. Prop 2 doesn't stop the city from raising it. My able opponent mentioned the rainy day fund. That's exactly what it is. It creates a fund. It's called the Taxpayer Relief Fund, but you can't spend that fund unless you get permission from the voters. So it's a backside budgetary limitation. It doesn't have anything to do with collection of revenues. You can collect all you want. And that's why this proposition poison pill language, if you think it actually got in there, which it didn't, never was triggered because Prop 2 doesn't relate to this. The last argument on this is that it's unconstitutional. I did plead that below. In the motion for summary judgment, it's been pled in all of the paragraphs of the petition, the live petition, pages 14, 15, 16, 17, 18, and the prayer for relief. So it's in there. And what we're saying there is it's an up or down vote. Either Prop 1 makes it on its own bona fides, and either Prop 2 makes it on its own bona fides, or they don't. They're not linked together. It's not like you vote, the Senate votes on a Supreme Court nominee, and it depends on whether another nominee is going to get in. You only vote on one thing. And if you vote by majority, it's in. And so they cannot, just because they gratuitously insert language that I call poison pill, they call primacy language, that then trumps Prop 2 because it didn't get enough votes. My last thing I wanted to say is, I think the two questions you asked my opponent put them in a gotcha. You asked if that language would apply with equal force on whichever one got the most votes. That's not correct. If you look at their adoption ordinance, the one that they put in the language, they say that this poison pill language is in Prop 1, not in Prop 2, in Prop 1. That's what their ordinance says, which was written gratuitously, self-interested after the fact. And now they're saying it goes either way. So I think their position is inconsistent. For those reasons, we ask that you rule in our favor. We're happy with everything the trial judge did, except the poison pill language ruling, and we ask you to reverse that.
If I may. All right, so, but this language, regardless of what you call it, was in the city ordinances that were signed by Bill White, I believe, on August 26th of 2004 before the election. That's not disputed, is it?
It was in the first ordinance unquoted. That is not disputed.
Okay, so aren't the citizens deemed to be knowledgeable of this provision?
No, because what was actually put on the ballot and what was actually the text is not what's in that ordinance. You have to decide as a matter of fact, what was the text of the proposition that the voters passed? And the poison pill language is not in the text. And the canvassing order after the election proves that. And if you get on the city charter's website right now, it also isn't in there. If it were in there, it'd be in that charter.
Do you have the record site for the canvassing ordinance handy?
I believe, and I'm sorry, I don't have all I can tell you, it's Exhibit 1A of our motion for summary judgment, but I don't have the pagination. I could supply that after the argument.
Not necessary. I'll find it. Thanks.
It's, the number is 2004-1168, and it was signed on November the 9th, 2004.
Okay. Any further questions? All right. Thank you, counsel, for your arguments. The case of Hotze versus Sylvester Charter in the city of Houston is submitted. Thank you again, and you're excused.
Thank you.